Back. Good. Denise, good. Back on the record in State versus George Allen Kelly, CR 2023-026. The jury, for the record, the jury began deliberations this morning at 8:30. At 8:30, the court received the following note from the jurors. Two questions, or two things. One, we need clarification of site visit. Was it demonstrative or an exhibit entered? Second thing is not a question, it's a request. Can we get multiple copies of the jury instructions, one for each juror? All right, let's deal with that one first. What's the state's position?
I don't have any objection to that, Judge.
To the instructions?
Sure.
We don't have an objection.
All right, good. So let's make sure, we'll copy off, 7 or 8 others. Just make sure they're all working off the same final instruction. All right, what about the site visit?
It's substantive, Your Honor.
Substantive?
Yeah, I mean, they're allowed to consider what they viewed out there as substantive evidence.
What was their question?
The question was, we need clarification of the site visit. Was it demonstrative or an exhibit entered? Admitted.
I don't know what.
I don't know why it makes a difference.
I think they're
Yeah.
trying to determine if what they saw out there was substantive evidence or if it's just a demonstrative, and I think it was substantive.
I don't know what do you have a position? It's the equivalent, well, the parties stipulated that locations 1 through 15, was it, were the locations that were specified, on the map, on the key to the map, or the key to the list that they got, right? I mean, so
Right.
that was, I think an answer would be to that effect. The locations that were marked, 1 through 15, were agreed to by the parties as being the locations identified in the key to the map, and you can consider that as substantive evidence of those locations.
Well, don't forget, Judge, don't forget that they added another point, and that was that tree. So
Oh,
I
the
don't know
tree
if
as
you want to
well.
be that specific and just call it, the whole thing is whatever you want to call it. But I think they can consider that location, in our opinion. I don't know.
Yeah, I forgot about the tree. But
Yeah.
15 was the last thing that was was it the
Pump
the
house.
the other
Pump
pump
house.
house that
Yeah.
we drove them out to?
Yeah.
And then, 16 was the not
Designated.
marked, but it was the end of the border
Yeah.
wall. And the
Oh, yeah.
tree, the parties went out there and agreed on the tree, so, right?
Yeah, I think anything they saw there was substantive evidence. That was the purpose of the
Yeah.
visit, was for them to judge distances and what they could see, all that
I
stuff.
mean, I agree, I just wanted to hear what your position.
Yeah, I don't think we need to, personally, I don't think we need to say 1 through 16, whatever, just the site. I mean, it's just, they may consider that.
Okay.
Just
Judge,
leave it vague.
That does raise an issue, though. We had asked that the photos that were taken by court administration be made a part of the record, just for the appellate record, in case anyone ever raises an issue about what happened.
All right, well, that's a separate issue. Let me deal with this.
Sure.
All right. All right. Well, you already have all those copies, right? So okay. We don't have to copy them off. We still have them, I think. All right, so answer one, you may treat / consider the site visit as an exhibit. It is not demonstrative evidence. Number two, yes, extra copies of the jury instructions will be provided. Any objection?
No objection.
All right, you can give this to them, and when you bring it back after they've seen it, give it to the clerk, and it'll be made for filing, and it's 8:45.
And then can we talk about that issue with respect to putting the photographs in for the appellate record?
Yeah, we will. Not right now. I got something else I have to do.
Okay.
All right. We're in recess.
Please rise.
You, please have a seat. All right, we're back on the record. Record show the presence of defense counsel and the defendant. The jury is not present. We have another request from the jurors. Who do we have on the line from the state?
Your Honor, Kim Hunley and Mike Jette from the state.
All right, good morning. So I marked this question came in at 10:05 a.m. Actually, it's not a question. It's a request. We need clarification on evidence admitted for a limited purpose and other acts, parentheses, pages 19 to 20, of final instructions. We are missing context.
Your Honor, I would suggest that what the state offered in terms of the limited evidence be read to the jury or be provided to them on the limited evidence issue. And we can talk about, and I wouldn't have an objection to sending them a message with respect to the text messages on the other act evidence.
Judge, I think that unduly overemphasizes that kind of evidence. We would suggest instead maybe something where you just told them at various points during the trial, I provided certain limiting instructions regarding certain pieces of evidence, and your notes and recollections can refresh that. But, for example, I talked a lot about hearsay, and things were offered for limited purposes. So what you recall about the trial is what that is about.
Right. I mean, but the problem with that is that's what I actually did in the closing instructions, and obviously it's not enough. What I would, and the reason I did that, and the reason it continues to be a difficult challenge to comply with this is that, there were a number of different things that were admitted for limited purposes, for different reasons, different types of evidence for different reasons. But I think we should try to respond to the request for information. So what I would suggest is that I write them back a note saying we intend to respond. The information is somewhat detailed and involved. We're working on a response. It'll take some time because it needs some work. And we'll get it to you as soon as we can complete it. Now, I would have the parties see what you can agree to as far as what the evidence was that was subject to the limiting instructions and what the limiting instruction was at the time.
May I get clarity? Is the note asking for which ones, or can we ask which ones are there in question about whether it has a limiting instruction?
I thought, yeah, it does not. It's just as read. Okay, we need clarification on evidence for a limited purpose and other acts. See pages 19, 20 of final instructions. We are missing context. That's all it says.
I mean, can we ask if there's a specific question or evidence or a statement made that they're in question on whether it is or not, versus giving them the whole trial of it?
I'd object to that, Your Honor. They've asked generally, and I think we should answer their question.
Well, I think we can do both. I think we can do both. So what I intend to write is just what I said. We intend to respond to your request. We are working on it. It will take some time because of the number of different things that were admitted in trial or for which a limiting instruction was given. However, if you have some specific evidence and you're concerned about what the limiting instruction was or whether it applies to that evidence, please let us know, and we will address that specifically. So let's try and do both, And we can get a response back. If they say it was concerning this particular item of XXX or whatever, then that helps us.
Clarity.
But in the meantime, I'd like the parties to work on this, and that would expedite the process and expedite any decisions that the court has to make about how to respond.
Well, Judge, I've already emailed to the parties and to the court what my proposal was with respect to the limiting instructions on Detectives Barba and Detective Rodriguez with respect to Miguel, Ramon, and Daniel. And so I've already sent that language. If counsel wants to take a look at it and see if they want to make some edits to it, we'd certainly be happy to talk to them about that and see if we can come to a stipulation to come back to the court.
That's what I'm asking everybody to do.
My concern is if we're going to give them some, it has to be all. And I'm not sure that's what they're asking for again. But, I think that's a lot of work because the court reporter, I guess, would be the only source of every single instruction. And so I'm just saying is I don't want to do just what the state wants that on. I want all of it because we don't know what they're asking.
All right. Let me craft an answer here. Thanks. All right, here's what I wrote. The court understands your request and is preparing a response. Two different forms of response, however, are available. First, We can prepare a response that tries to list all individual items of evidence admitted for a limited purpose. We can do this. It will, however, take some time. Second, if there is a particular item or items of evidence that was admitted for a limited purpose and the jury has a question about those particular items, the court will prepare a response as to why that item or items were admitted for a limited purpose. Either response is acceptable and doable. Please let us know how you would like us to proceed. How's that? Ms. Hunley?
Your Honor,
In the meantime, I still want the parties to start working on the more comprehensive response, and let me know what you come up with. So if they decide they want the comprehensive response, then we can try to make that happen.
And Your Honor, we're going to head over as soon as we get off the phone and start working on that with counsel. But I would still like to provide a comprehensive response to the jury as to those two issues, one way or the other. We requested it before. I don't want to waive any objections or any issues with respect to that, and so I think they're entitled to know those two things. But aside from that, no objection to your response.
All right, very well. So I'll give us the bailiff to take back in there, and come on over, get working on that with defense counsel. I assume we'll get an answer back from the jury pretty quickly. And once I get that answer, I'll come back into court and let you know what they say.
Sounds good. Thank you, Judge.
All right, we'll stand in recess. Thanks. All right, we're back on the record briefly. The jury just told the bailiff they're holding on to the note. They're going to decide how to respond. So that's what they're doing. So in the meantime, keep doing what you need to do. But I just wanted to tell you that's what their response was. So they haven't returned the note. They're working on it, and they're going to decide how to respond. All right?
Is that like the medical examiner? They're still thinking about it.
Do they need the skeleton?
I would like to make a record on it again at some point, so, just so the court knows.
Thank you. Right, we're in recess. Thanks. Nope, we don't have anybody here. Thanks, everyone. Have a seat. I think the prosecutors are on their way. You can go ahead. Go back in there. Just hold, no, don't open it. Just hold that door. Everybody ready? All right, we're back on the record in State versus Kelly. The records show the presence of all counsel and the defendant. About 10 minutes ago, we got another note from the jurors. For the record, I previously instructed my judicial assistant, Jose, who's also the bailiff, that if the jury ever submitted a note that had any kind of tally or numerical representation about what their votes were, he was to close the note and not show me the note. And the reason I did that is I've had this happen in a number of trials before. The jury instructions, the final jury instructions that I gave clearly state to the jurors, and I think I emphasized to them again, if you have a vote and you have a note, you're not to inform the court about where you are in the vote numerically. Well, apparently they've done that. Now, I haven't seen it. I intentionally didn't look at it. I had them staple it and gave it to the clerk. If you would just write on there, Valeria, one that came in about 1:45 today on April 19th. But I haven't seen it, so I don't know what it says, and I don't think it's appropriate under the law for me to look at it. And that's all, apparently it's in the note. It just has, my understanding, it has the counts of the charge and just some kind of tally of where they are. And then they told the bailiff orally, well, what do we do now? And I sent the bailiff back to give them instructions. Any questions for the court have to be put in writing. So that's where we are. But in the note doesn't ask the court to do anything at this particular point in time.
Your Honor, I still don't think we've answered their questions from earlier.
I did answer their questions, but they haven't sent the answer back. So a question on the limiting instruction, I read it, and it says we can do this either way or both ways. We can answer your question. We can provide you with that information, and tell us what you want us to do. And we haven't heard them back. So if they had answered back, then we would have gone forward. But right now, putting that aside, let me hear from the parties. I mean, I haven't been asked to do anything, and so unless and until I'm ever asked by them to do anything, my intention is not to respond.
Well, it's the state's position that we need to give a full response to their request on the limiting instructions. So the state is still requesting that, specifically with request to Detective Rodriguez.
All right, I know what your request is. I'm not going to do it. I already responded to that request. I responded to the request that they gave me. I told them what we can do. I said the court can respond. We can give you all this information. If you have some specific area of concern that you want, we'll answer that. If you want it all answered, if you want us to tell you about all the limiting instructions we gave, we'll give you that detail as well. Put it back in that court. Haven't heard back from them. From that, I assume it's not that important at this point in time. Anything else record you want to make about the note that was just sent out? Other than what you've already stated?
It sounds like you've already responded, Judge? Or,
No, there's nothing to respond to. They just sent a note out with a tally about where they were on the various counts. And I haven't responded in any way, except the bailiff told me they orally told him, well, what do we do now? And he did not respond appropriately, and he informed me of that. And I sent the bailiff back and said, if you have any questions of the court whatsoever, everything has to be done in writing. And that's where it sits. What's the defense position?
I think we can leave it there unless and until they send us something that is in writing. If they say we're stuck or something like that, then we can give an impasse instruction. But I think we need to wait for something from them.
That's what I think as well. But start looking at that. I think generically they're called Willits instructions. There's a Arizona revised.
It's not called Willits, Your Honor.
I mean, that's what we
Willits.
kind of colloquially had referred to them. But there is an Arizona revised jury instruction that is recommended for the court to give, if appropriate, under the circumstances when the jury has indicated they're at an impasse.
I was just wondering, Judge, if you wanted to send a note to remind them to not tally up on future notes. And I don't know. Whether it's necessary or not, I'm not sure. I mean, we hate to come back with...
It can't hurt. I mean,
Because you don't want another one saying we're hung, we can't figure out what do we do, here's our tally, and then it makes it where you can't read it.
Can't even read the note. Right,
Yeah.
That's true. All right, I think that's a good idea. Let me have some kind of...
Something to write with you?
something.
Your Honor, and I know you believe that I've made my record, but I indicated earlier I needed to make a further record, and I would like to make that further record, which
You
is
can
that
do
the
that,
state-
but I'm trying to deal with an immediate
Sure.
issue right now, so let me deal with this. All right, so, and I'll put April 19th, 2:05 PM. Jurors, you are reminded not, underscored not, to inform the court, bailiff, or anyone else what your numerical vote counts are on the charges. All right, I'll give this to, any objection from the state?
No objection, Judge. And just
All
for
right,
the
let me give
record,
this, we'll have the bailiff take that.
and just for the record, Your Honor, I think you meant an Allen instruction. Willits is if there's lost or destroyed evidence.
Oh, that's right. You're
Is that
right.
what you
Yeah.
meant?
Yeah, I'm sorry, I forgot that. Thank you for correcting me. Do you have that? Does everybody have that proposed, Raji? We're not there yet, I just take a look at it.
Standard 53, is that what we're talking about, the impasse instruction?
You're right, I think so.
I
Are-
have it in front of me.
Okay, take a look at that. We're not there yet, but the way things look, we may be soon. They, for the record, the jury began deliberations at 8:30 this morning. Well, let's go back. Yesterday, they began deliberations at 2:40. It took us a little while to get some of the exhibits back in there. They recessed at 4:30, so that was an hour and 15 minutes. They began deliberations at 8:30 this morning. We got the note at about 1:45, 1:50. They did have lunch brought in. I don't know if they worked through lunch or not, but they began at 8:30 this morning and sent the note out at about 1:45, 1:50, and stayed in for lunch. Ms. Hunley, you can make an offer of proof and a record. Why don't you just print something up? I've got other things I need to do. If you would write something and print something up, and then you can file it and make it part of the record.
Well, Your Honor, it's just the document I already prepared and already submitted to the court that I just believe the state is prejudiced without the jury receiving that information. And I don't believe they know how to ask for it because they don't know what it is that they need the information on. So I think pitching it back to them is not appropriate. I think that we should offer them the information that they asked for.
Okay,
That's all.
understood. Any change in the position from the defense on that?
No.
All right, stand by. We'll be in recess.
Please rise.
Please be seated. Not unexpectedly, the record will show the presence of counsel, the defendant and defense counsel. Not unexpectedly, we just got another note. I marked it 2:10 p.m. The note reads as follows. We, as a jury, are at an impasse as to a unanimous verdict. We're looking for guidance as to how best to proceed. I'll give a note to the clerk. What's the defense position?
I don't know that we need to give the impasse instruction just yet. I think maybe just another note
I
saying.
can't hear it. I don't think.
Oh, I don't think we need to give the impasse instruction just yet. Maybe another note saying, do your best, see if you can make any progress.
I think when the jury indicates they're at an impasse, we have to give the impasse instruction.
So the impasse instruction, just make sure we all have the same thing. We're looking at the same thing as Standard Criminal 53, and it reads as follows. This is offered to help you, not to force you to reach a verdict. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a just verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your views and change your opinion if you become convinced that it is wrong. However, you should not change your belief concerning the weight or effect of the evidence solely because of the opinions of your fellow jurors or for the mere purpose of returning a verdict. You may wish to identify areas of agreement and disagreement and then discuss the law and the evidence as they relate to the areas of disagreement. If you still disagree, you may wish to tell the attorneys and me which issues, questions, law, or facts you would like us to assist you with. If you decide to follow these steps, please write down the issues where further assistance might help you bring about a verdict and give the note to the bailiff. The attorneys and I will then discuss your note and try to help you. I do not wish or intend to force a verdict. We are merely trying to be responsive to your apparent need for help. If it is possible that you could reach a verdict as a result of this procedure, you should consider doing so. Please take a few minutes and discuss this instruction among yourselves. Then advise me in writing of whether we can attempt to assist you in the manner indicated above, or whether you do not believe that such assistance and additional deliberation would assist you in reaching a verdict. If we're going to give them an instruction, I think we ought to give them this one, because it's crafted to be neutral, offering help, clearly states we're not intending to try to force a verdict, coerce a verdict, or influence a verdict. It's just, tell us whether you need help, can we help you, is additional time needed, or are you clearly at an impasse?
In my experience with my background, I have found that sending them back to do their due diligence, some note to say, keep trying, before they just throw the towel in easily, and then follow up with this has helped a lot where we did get verdicts. It's just my experience.
The state opposes that, Your Honor. We'd ask for the impasse instruction. It's specifically designed for this situation, and as the court indicated, is neutral.
Let me get a formal statement from the defense. You, co-counsel, you can talk together, talk to your client if you need to. It's an important decision. If you want to involve him, do so. I can step off even, but really the question is whether or not I give this impasse instruction. If I give further instruction, I think it's appropriate to give the impasse instruction, because it's crafted to comply with the case law and to be neutral and to be non-coercive.
The instruction is not a concern. We know that's crafted for that purpose, and so that's not our objection. We would just like them to continue trying for a while before they get back and give us more information that they absolutely can't. The same issues may be the same issues in another trial down the road. So I think what I have found by just asking them to get back to work and continue to try, and then maybe they'll diligently try a little harder and then follow up with this impasse note if we get another one down the road.
All right, I understand your position, but if I am going to give a reply, a response, then I'm going to give this instruction. But I won't give it. Well, I'll consider not giving it if the defense objects. I mean,
We'll take a minute.
Okay, I'm going to come back in a couple minutes. We'll be in recess for 5-10 minutes.
Please rise, que por favor.
Why don't you go see if the defense people. Go get the defense. Thank you. We're back on the record. Records show the presence of counsel and the defendant. I've been thinking some more, and I am going to do what defense counsel suggested. This jury, as I said, went out at 2:40 yesterday. It took us a while to get the evidence in there, and they did deliberate a little bit yesterday, and they deliberated today from 8:30 to a little bit before 2 with a lunch break. Not sure whether they worked before lunch. They just It's a 4-week trial, a lot of complex information, a lot of proof, a lot of evidence presented, and there's a lot of issues. I mean, there's no question. There's a lot of facts to be looked at in this case. I just don't think they've worked long enough or hard enough at it. So I'm going to bring them in, and I'm going to tell them, number one, I don't know what their vote count is, and again, they're not to tell me, but it's a 4-week trial. A lot of work and effort's been put into it. I'm not trying to coerce a verdict or influence them in any way, but I think they just need to keep working. Another possibility would be, we are here on a Friday afternoon. I'm always concerned when a case goes to a jury on a Friday and a Friday afternoon that influences their process. Another option I can offer them is, look, if you want to break today and come back Monday and start again Monday, that's another thing we can offer you. Sometimes that's an effective thing to do, which is just to take a break and come back and start afresh on another day.
For the record, the state opposes that, Your Honor. We're asking for the impasse instruction. I believe it's specifically designed for this situation. The jury specifically said they're at an impasse, and that covers all of the issues.
Yeah. All right.
We're in agreement with your suggestion, Your Honor.
Okay. Then let's bring in the jurors.
Please rise.
All right. Yeah, sit anywhere you want, ladies and gentlemen. Please have a seat, everyone. All right. The records show the presence of all of the 8 active deliberating jurors, counsel, and the defendant. Good afternoon, ladies and gentlemen. I've been reading your notes, discussing your notes, and content your notes with the lawyers. It's 2:35 today on a Friday. This case went to you for your deliberations, ladies and gentlemen, about 2:40 yesterday afternoon on Thursday. We took a while to get the evidence together, put it all together so you could have it all available to you in the jury room. Then my understanding is you began your deliberations again this morning at 8:30. You had lunch. I don't know, did you work through lunch or did you just take a lunch break? Work through lunch? All right, that's good to know as well. And then your latest note came in at 1:50 p.m. about the situation. Again, just to remind you, I know I've written it back in the note, do not advise me numerically of where you are voting, okay? I had it stapled up and filed with the clerk, so I don't know where you are. Please don't do that again. That has an effect that I wish to avoid. Now, I have to tell you, it's my opinion that you haven't worked at this long enough. This was a 4-week trial. A lot of evidence was presented, a lot of information, some of it very complex from a variety of different witnesses. I mean, I don't know how many witnesses we had testify, but quite a few, and they all gave important information. So very complex information. I understand the issues are complex, but to come back on a Friday at about 1:50, I don't think you've worked at this long enough. I am not trying to force or coerce a verdict, all right? That is not my intention, and that's not my job, and that is not what I'm doing. But I do have a responsibility, after a tremendous amount of work has been put in to getting this trial to this place, where we are, by the lawyers, by the court, all the resources that have gone into it, and all the evidence that's been presented, to make sure that you do your job, follow your oaths, and to work as hard and long as you possibly can to reach a verdict. Again, I'm not trying to force or coerce a verdict, and if there's things that you need and we can help you with, other information or evidence, that's what we're here to do. But in my opinion, which is the one that matters at this point, you have not worked at this long enough. So I'm going to send you back in a moment to continue the deliberations. Now, also, it's a Friday afternoon, and from my experience, from a lot of trials I've done, sometimes, and this is something else for you to consider, sometimes it's good to take a break. I know everyone's prepared and eager to resolve this matter in this case, but another option would you can be recessed for the day and come back Monday. Sometimes it's good to take a break, step away from it, and come back as a group, again, 8 persons on Monday after a weekend, and start the deliberations again. So that's another option for you. So what we're going to do is I'm going to send you back in the jury room. I want you to keep deliberating, discuss it, keep an open mind, reevaluate your positions if you feel that's appropriate, and continue to work on this case. All right? And if you decide you want to break for today and come back on Monday, as I've suggested, pass a note to the bailiff, and then we'll just excuse you for the day and tell you to come back Monday at 8:30. But I want you to keep working. All right? You're excused to continue deliberations. Thank you.
Please rise if you prefer.
The record will show the absence of the jurors. I kind of doubt they'll take me up on it, but if they do take me up on it and decide they want to come back Monday, we'll let you know right away. All right? Otherwise, stand by, and we're in recess. Thanks.
Please rise.
Thank you. Please be seated. All right, we got another note from the jurors. I had it shown to counsel just because this juror writes so small. I just want to make sure you have the same reading of it that I do. The way I read this, were the SO reports entered into evidence? If so, can they be shared with the jury? Is that the way you folks read it? All right. Let me hear from the state first.
Your Honor, I think we have to answer, they have all the evidence that's been admitted.
That's fair enough, Your Honor.
All right.
I think we can tell them that they can have additional testimony if they request it as well. There's an additional instruction that indicates that, and a rule that allows it as well,
And
if that would help them.
Our position would be to not suggest that.
We didn't have any reports that were admitted, right, from the sheriff's department?
That's correct.
Not police reports, Your Honor.
Right.
Obviously, that's because we can't admit them because they're hearsay.
All right, so my response is, by rule, the admission of evidence stops at the close of the trial. No other evidence can be admitted. The SO reports were not admitted during trial, hence they are not in evidence and therefore cannot be shared with the jury. Any objection?
Yes, the state objects, Your Honor. It sounds like we could admit them, which we cannot. They're hearsay. And I think that improperly emphasizes that they weren't admitted and seems to point the blame at the state for not admitting evidence, which we're not allowed to admit.
I don't have a position, Judge. I think how you crafted it is fine, but I understand the state's objection.
All right, this is the instruction, or the answer I'm going to give to the jury. And it's 3:15. We're in recess.
Please rise and come forward.
All right, we're back on the record. In State versus Kelly, the record would show the presence of all counsel and the defendant. It's 4 p.m. I marked this latest note from the jurors, 4 p.m. The note says, jurors would like to be dismissed and to return Monday at 8:30 a.m. Any objection?
No.
No, Your Honor.
All right, so I'm going to write, you are dismissed. Response I wrote is as follows. You are dismissed. Please return to the jury deliberation room Monday at 8:30 a.m. to continue your deliberations. Remember and comply with the admonition of the court.
That works for us, Your Honor.
Yes, Your Honor.
All right, I'll sign it, Judge Fink. Hand it to the bailiff to be delivered to the clerk. And we're adjourned until 8:30 a.m. Monday morning. Have a good weekend.
Your Honor, could I address one issue first? We've requested a copy of the JAVS recordings of the trial in this case, and pursuant to Administrative Order Number 2007-015, it indicates that if a party requests a copy of the JAVS recordings, they're entitled to them. And I was told by the clerk of court that the court was indicating I'm not entitled to them, so I'm just trying to sort that out.
I understand. It's been brought to my attention. And put your request in writing, file it with the clerk in connection with this case, and the court will give you a ruling.
Okay.
We're adjourned until 8:30.
Please rise and come forward.